Hi, my name is Michał Pękała, and today we'll talk about video game clones. Before we do, a few words about the speaker. I work with the Maruta Wachta law firm located in Warsaw, Poland, and together with my several associates, we advise video game companies from all of the sectors in the video game market. We advise developers, publishers, investors, freelancers in various contracts and legal issues that they encounter while doing their business in Poland and abroad. Together with my colleagues, we advised so far almost 60 video game companies within different stages of development and different size of the companies, from establishing small companies of 2 or 3 friends to the companies that are joint stock listed on the main Warsaw Stock Exchange as well as New Connect. Before further ado, let's jump to the presentation. Every market has something that boils up the temperature and the blood that comes within the veins of the people associated within that particular market. The same goes with video games. And one of that aspects that is especially important and heated in terms of passion and the way that the spectators of the video game market speaks about it are the video game clones. But what are the video game clones in particular? What are they? We often talk about video games clones in a very defensive or negative way, but what is the definition of the video game clones? And to come up with the very short answer, there is none. There is no official definition of the video game clone. There are various definitions which have been developed by the practitioners and people involved in the video game market. But the best definition that I have encountered is actually on the Wikipedia. And according to the Wikipedia, as you can see, the video game clone is nothing else than just a video game or the video game console, which is very similar or heavily inspired by an other game or the video game console. And this very short definition explains everything that stands behind the video game clone. It's nothing else than a game that has been built on the success of the previous title. Coming to the clones in general, there is no such thing as just a video game clone. There are types of video game clones, there are different angles that you can approach the video game clones, either by trying to create one or try to interpret one. And for the purposes of our talk today, I have come up with 4 examples of the video game clones that are usually the most common that you can encounter. And of course, the first kind of video game clones are those that have been made specifically to gain the financial advantage on the success of the game which the clone has been based off. And this is particularly important in terms of, for instance, the entire mobile sector, where a particular video game developer come up with some kind of brilliant idea for a new game to be launched on either iOS or Google Play. And immediately following that, another video game companies, usually smaller, take advantage of that success and create similar clones, not to make anything new or add to the genre, but to just rip off on the financial success of its predecessor. The another already mentioned example is the building of the genre. And this is basically the entire concept of creation of video game clones, which is somehow elusive to most of the spectators because it's easily overwatched that actually the clones themselves are not bad in general. They are bad if they rip off on the copyrights or other rights, proprietary rights associated with the original. But in general, clones add up to building genre and to development of the games as an art. And I will explain you in later stage of the presentation, based on the examples, why I personally believe that video game clones are not necessarily bad. And actually, I think that all of you, if maybe most of you, played various video game clones and you enjoy that, and you have never thought about that video game clones in a negative perspective. Another examples of the clones in general are the homage and crossovers. They are usually linked together and somehow may be mistaken for each other. Homage is nothing else than some kind of a tribute to usually to the older games, for instance from previous generations, and somehow the retrospective view of the games that are being developed right now, for instance the entire pixel art genre, which is nothing else than a nod to the late 80s and 90s of the video game industry, where people which are now young didn't have chance to play the original games in the first stage of development of the industry, but now they encounter the possibility to also have the same experience as the older people, as me for instance. The crossovers is something that is very, very common and usually entails some kind of taking a small aspects of the previous games to include them in our games. For instance, in terms of Easter eggs or some kind of other mechanisms which are used in various genres. For instance, if there is a good example of the explanation of the knowledge encyclopedia within the game, which the game, for instance, would be the RTS genre, nothing stops the developers from taking the idea of the encyclopedia to put it in the RPG genre. So the examples of the clones in general are multitude. I only came up with 4 of them, but it's very easy to come up with the very longer list of that. Unfortunately, not everybody thinks in the same way as I do. And either because the original creators of the video games feel that they are being ripping off by the successors, building on the genre of the original video game, or truthfully or not truthfully, they believe that the new video game based on their original title in some way infringe on the rights. And in that example, which is the prime aspect of this conversation today, is that the legal kicks in. And when the legal kicks in, it's only necessary to outline the 4 aspects, the 4 areas of law, which will be used either by you or by other companies from the video game market to try and establish whether the particular game as a clone infringes on the rights. And the most important, and I mean it's even underlined by me in the presentation, the most important area for you to remember in this regard are the copyrights. The copyrights are everything that you can see in the video games. It's basically everything that it's in the game from the visual perspective, as well as the underlying source code of the game understood as the computer program. So for the generic viewer of the video games, everything that it sees, he or she sees, and everything that he or she encounters lights up on the copyrights themselves. It's the story, are the dialogues, it's the UI, it's the graphics, the characters, it's basically everything that in some way makes the reaction with your perception and the way how you see and how you absorb the game itself. So for almost all of the cases that you can see on the internet, you can hear about from your friends or from the news or other media, are based on the copyrights lawsuits. And these are the most important. I will show you on the examples in a minute. Another 3 are also important, but they are more difficult to use within the battle against the clone, where you feel that that clone infringes on your rights. And these are trademarks and patents in general, where trademarks, they stem to the logos, the name of the game, the name of the characters, or sometimes the name of the company. When it's used to some kind of hinder this new game behind your own title, you can use trademark as a way of protecting your rights. Patents are even more difficult because to use a patent, you have to have one in the first place. And to have a patent, you need to file it in the patent office, either in your country or some other country, wherever you feel would be the most valuable to you to have that protection. And by just giving an example, a very small example of video game patents, there are a lot of video game patents in the industry and you don't even know it. The best example that I always come up with, it's this pointing arrow in the Sega game from 1994, as I remember correctly, to point you the right direction when you use the car going around the city. This is a patent, and that patent entitled Sega to forbid other companies from using the same arrow or similar arrow as a mechanism for 20 years following without the consent of Sega. Another two bullet points within this spectrum are the trade dress and unfair competition. And trade dress is basically very similar to trademark in a way, and it stems to the general view of the interface, of the UI, the items used within the game from the operating level. So for instance, from the perspective of RTS genre, if you have this bottom bar like you have in any RTS from Blizzard back in 90s and early 2000, you will have the minimap, the pointing, you will see the small bar showing you the units within the which you selected to move, or some other options like the menu or the chat box for instance of multiplayer game. That can be protected by the trade rares and to some extent can be used to protect yourself from other clones. Unfair competition is the most elusive way to protect yourself, and basically is usually tailored to the concept of non-disclosure, the confidential information, the use of your company in general to try and hinder the new concept of the video game clone behind the name of your company. Sometimes it can be mistaken with trademark, and sometimes it's very easily mistaken by trademark, even by lawyers using this tool. But this is also to remember that these four items are the cornerstone, the basis for legal battle against video game clones. So that we know already what types of law can be used against the company creating video game clones, now let's talk about what can happen to the company that decided to make a video game clone. And to put it in a nutshell, there are two main outcomes of that battle can emerge in terms of the legal perspective and one from other perspective. So for the company that decided to make a clone and later being sued by the previous company, the owner of the original idea for the game, the most but not necessarily the most common threat is that the game will be blocked in terms of distribution. So if the original owner of the game wins within the court can award that plaintiff with the order for your game to be stopped, to be blocked from distribution. So imagine if you put a lot of money in creation of video game clones and you didn't care about whether your game will potentially infringe of the copyrights or other rights of the original game, your game may be blocked. So imagine you spend $2,000 or $2 million on creation of a small game as a new studio, and your game is being blocked from the day one. This is a disaster for any company, but for the small company, it's usually a killer. Another threat that can emerge and usually is associated with the first one are the damages that can be awarded to the original owner of the game. So the original owner of the game will try to establish in the court that because you created a video game clone, damages occurred on the side of the original owner, and the court will be asked to award a substantial amount of money for the compensation for the original owner. And now, depending on the country that you are seated in and the plaintiff is seated in, and the country where the case is being administered by the court, there are different ways to approach the damages themselves. For instance, in Europe or Poland, for instance, the damages will usually be limited to the actual damages that have been suffered by the original owner of the game. That can be, for instance, the multiplication of the price of the single copy of the game multiplied by the number of copies actually sold by the infringing company. So if you sold 1,000 copies of your game and every copy of the game costed $10, you will have to pay $10,000 in damages. But for instance, if the case were to be administered in US legal system has some other approach to damages, and for instance, there is a concept of punitive damages, where in addition to the damages actually suffered by the company, the court may award punitive damages to somehow made you stop thinking about having the same approach or idea about creating a video game in future. And in practice, it can result in a situation where you will have to pay $10,000 as actual damages, and for instance $1 million as punitive damages. And that kind of money can be disastrous for everyone. But these two legal threats are not the only one. I don't have to tell you that if you go to court with your first game, or even with your second or further games as an established studio, and you lose, and everybody knows that you are the company that creates clones and reaps off on the benefit or the financial success or the idea of the previous games, the reputational damage can be disastrous to everybody, especially if you are a joint stock company. But what happens when another studio thinks that your game rips off on the copyrights or other proprietary rights of that company? Before we even think about going to court, let's talk about what can happen when somebody is pissed off because of your game, and what can be the outcome of that dispute. Sometimes you may receive a letter or an email or even an angry telephone from the company saying that, hey guy, you just ripped off of my game, and you either take down this game from Steam or any other platform holder, or I will sue your ass. And that can happen. And if that emerges, you have basically two options to follow. The first option is the Armageddon one. You just go to court. You ask your friends, hopefully they're lawyers, to help you out with the lawsuit, and you come up with the defense and how to convince the judge and sometimes the opinion of the public that your game is not a clone. This is the Armageddon option. You go to court. You have to invest some money and your time and personal effort to battle that lawsuit, and unfortunately, with the detriment to creation of your another title if you decided already, or further development of the game that has been accused of being infringing one. That's the first option. The second option is a settlement. And there is a lot of lawyers that will tell you that if asked whether to go to court or settled, they will always say to settle. And although it's very tempting to say that in this example as well, it's not that simple. Because nowadays, the approach of the companies, not necessarily the biggest ones in the video game market, is that let's try and sue everybody if the game created by the new company, even in a smallest aspect, used the idea, the concept of our game, just for the sake of them dropping the game and trying to settle with us. Let's say that you decided to go to court and battle, or you decided to sue another company for their video game clones. The court in general will use some kind of tests to try and establish whether your game or the other one infringes on the copyrights as a clone. The first test that is usually used by US courts, and most of these tests will come from the US law doctrine, is the FAC test, the Abstraction Filtration Comparison test. And it's basically, this test is kind of old. It's from the 1980s and was originally for the first time used in the movie genre market. But this was also used for the video games, and I will show you an example in a couple of minutes in which case. But in a nutshell, the AFC test works in the following way. There are three stages: abstraction, filtration, and comparison. The first stage, abstraction, is a place where a judge identifies what aspects, elements of the game constitutes an ideas which are not protected by copyrights and which are the expressions which are protected by copyrights. The idea, for instance, is the game about medieval knight that decided to go on the adventure and kill the dragon. this is not protectable. But the expression is how you portray that knight and the journey and every person and every monster and every quest that he will encounter. The appearance of his armor, the appearance of his sword, his face, the entire storyline. This is expression and that's protectable. Another stage, the filtration, is after the judge successfully is left only with the expressions elements of the game that is being subject of the comparison. He now further filtrates the elements which are copyrightable from the general perspective, but cannot be legally protectable by copyrights in this particular element. And for instance, if somebody is using in a game the buildings which are within New York or some other city in the world, there are some elements, the legal mechanisms that can be used here to further filtrate that areas for being protected. And the example used by saying that the New York as a city can be portrayed is the panorama exception. So every building, almost every building in the world, with some exceptions, of course, it's a law, is not protectable, and everybody can portray that kind of city, the skyline, the particular buildings. So all of that elements and many others, like the national flags and some other elements which are sometimes connected with government or some kind of public authorities, are not protectable. And after that filtration stage, the judge is left with comparison. And at this stage, judge has only the elements that can be protected within this particular game, and these elements will be then compared to the game that is being accused of infringing. And based on that test, judge then evaluates whether the amount of differences between these two games are enough to say that the game is not infringing, or there are too little of the differences, and the judge decides that the new game is actually infringing. Another legal theory used by judges in establishing whether the video game clone is infringing or not is the sin of fair principle. Pardon my French, I will butcher this name every single time I try to say it, but it's basically the sin that must be done as a translation in English. And it basically works in a way that under the copyright principles, there are certain elements of the work being created that cannot be protected by copyright itself, even though they're arts, because the use of them is mandated by the custom of the genre of the game that they are within. And for instance, if you have the fighter genre, let's say the Street Fighter or Mortal Kombat or any other video game that is associated with battling two opponents against each other, it's only logical that both of these opponents will be shown from the perspective in 2D. One will be on one end of the stage and the other one will be on the second end of the stage. And also the health bars that are used behind their heads, it's a customary way to portray that either this opponent on that one has particular aspect of it's very little or very large amount of health necessary. The same for the experience bar, the same for the super energy bar, the same for the UI for RTS games, which copied to some extent the idea that was created originally by Blizzard and also developed in future. So in a nutshell, everything that in some way can be said that it has to be done in a specific way because that's the genre of the game, usually falls within the sin of fair legal theory and can be used to protect against the accusation that your game, for instance, is being a clone that infringes on the right of the original game. Probably the most difficult legal theory to explain in a nutshell is the look and feel approach. And the look and feel approach is from the three of these legal theories that was presented to you is the newest one, it's the youngest one in terms of use within the video game market. And the look and feel principle to some extent can be associated with the AFC test, already explained by me, but it's a little bit different and is a little bit more. And it stems out, it's based on two approaches. the look and the feel of the average spectator that is put in front of the game and asked how it feels about the game that is being presented to him or her. So the look aspect comprises all of you can see, and it all falls within the expression, but also the idea of the game put in the more graphical, perceptive approach. And it includes the UI, the graphic elements, the shapes, the colors, the shades used within the new game when it's being compared to the old one. Even though both games may not necessarily be the exact ripoff of the copyrights in terms of using the same font, the same colors, the same shades, even though they are different, if the differences are not substantially different, a judgment say that, okay, based on the look, both games seem to be very, very similar and a little bit too similar to be distinguished as separate arts within the copyright law, and the new game will not infringe of the old game. That's the first layer. The second layer is even more elusive. It's called the feel. And the feel is more of the underlying mechanics, the underlying gameplay of the game. Imagine that you want to create a video game that it's being a ripoff of the game that has been already created. And you know how to approach the graphics, how to approach the visuals, and you change everything. Let's say that the original game, there is very realistic graphic, and in your game, it's very futuristic and very cartoonish, for instance. But the very feel of the game, the gameplay mechanics, the specific buttons, boxes, menus are basically the same. Only the visuals are different. The story is the same, the concept is the same, the entire approach to the game, the feel of play is the same, but only the difference is in the graphics. If the judge feels that both the look and both the feel are met here, it can be established that your game or the game of the company that you feel being ripped by is basically the infringement of copyrights. And on the examples in a couple of minutes, I will show you the exact example of the look and feel comparison that I have in mind. So let's jump to the examples. One can't speak about the examples of the video game clone cases without mentioning the Atari versus Amusement World from 1981. It's the first and one of the biggest landmarks within that kind of cases because it's probably the first one when the judge used the AFC test to distinguish the idea versus expression. So Atari created Asteroids, and Amusement World, following that success, created Meteoros, its own game. And Atari was not very pleased with seeing very similar game following up their own success. So they sued. They went to court and they said that Meteors are the ripoff of the Asteroid games. And what the judge did? The judge said that the idea used by the Amusement World was the ripoff. They used the very same idea that was used by Atari to portray the lone spaceship in the space battling the big chunk of asteroids, meteors, chunk of ground that is floating around the screen and trying to survive and kill them with some kind of, destroy them with some kind of weaponry that was established on this spacecraft. So what the judge said beside the fact that the idea for the game was used, they said that even though the idea was used and is actually the same, the idea is not copyrightable and it can't be protected by Atari. That other developers are entitled to use the very same idea to create the lone spaceship battling the rocks within the space. Further than that, after the judge distinguished that the idea is not protectable, he went to the layer of copyrightable elements and tried to compare them. And what he did, he said that the graphics, the colors of the meteor rocks are different. In asteroids, they are white and black. In meteors, they are colorful. Further, the ways of shooting of two spacecrafts are different. In one game, it's a blast. In the other one, it's a constant fire. The actions after the spaceship distractions are also different. The difference was also in the beginning of the game. In asteroids, the spaceship already started every mission within the space, while in the meteors games, he jumped from the ground, from the Earth, and only after a couple of seconds he appeared within the space. And in multitude, like in the overall comparison, the judge said that there are at least 22 similarities, but there are also 9 differences between the game. And subsequently, the judge decided that those differences, they are enough to say that both games are different. And what's the takeaway from this example for you is that if we look at these pictures of these two games right now, they seem fairly similar to each other. But please bear in mind that this case is from 1981. And at that time, the level of sophistication between both games, even if the colors of the meteors were different, was enough for judge to say that the game is different right now. These days, it's not that easy. But let's go to another example. A year after the first landmark case, Atari versus Amusement World, Nintendo sued Elcon for the very same reasons. Nintendo created Donkey Kong and Elcon created subsequently Crazy Kong. And they sued on the very same basis, that the Crazy Kong was the straight ripoff of the Donkey Kong of Nintendo. So they went to court, and what the judge said, that although the idea itself is not protectable, he followed the same ruling that was made a year before in the previous case, but he said that the expression of that idea is substantially similar. He even said that it's vertically identical for these very small differences like the colors of the level itself, the colors of the main protagonist and main antagonist. They are different, but the shapes, the very expression of the entire levels are so substantially similar that for judge in this particular case, he had no doubts that there is a copyright infringement in this particular case. And Nintendo won. The same year as the Battle of Kongs, we had another example of the ruling in the US concerning this time Pac-Man versus Munchkin. So Atari created Pac-Man, very, very successful game. I loved this game when I was using Pegasus in my youth. But Philips decided to make Munchkin, a very similar genre game, but it's with a slight of different approach to the level, to the main protagonist, and to the main antagonists. But Atari sued Philips for copyright infringement, and in this case, we can see the use of the sin of fair legal theory by the judge. Judge said that, okay, Atari, you cannot say that the building of the level, the use of the elements such as the tunnel exits, the use of dots can only be used by you, because for that the genre of the game itself, there is no name of the genre itself, but for this particular genre games, it has to be portrayed in similar way because it's the sine fair. That's why Philips, to that extent, did not infringe of the copyrights of Atari. But that's not the outcome of the case. Even though the judge said that we can apply the sine fair principle in this example, Philips still lost the case. And why he lost? Because the judge also found that for other elements, such as the shape and size of the main protagonist, the V mouth that is used by that protagonist, the reversal mechanisms, where from being chased by the ghost, if you are empowered enough as a main protagonist, you can actually chase the ghost or the monsters by you and eat them, it's the same. The ghost's eyes and legs movements also struck the judge as too similar for each other. and also the way of disappearing of the main protagonist, as well as the ghosts and monsters, followed in the same direction as being too substantially similar. So as an outcome, judge decided that even though the Phillips was completely okay with using the general shape of the tunnel, of the dungeon, the dots, and the way of chasing each other, he could use the different size of the main protagonist, different monsters. The role reversal mechanisms was not necessary for this type of game, and Phillips lost. 12 years after Pac-Man vs. Munchkin case, yet another case emerged in US. Street Fighter II versus Fighters History, Capcom versus Data East. And in this case, it was fairly standard approach from Data East to follow the example already outlined by Capcom, by creating the game where different protagonists fought each other in duels on various levels, like streets, like dojos, like mountains or beaches all over the world. And they used the same elements like the bars, like the health bars, like facing both protagonists from the 2D perspective, from only single angle, using different powers, superpowers, sometimes using also elements like some kind of weapons, and of course punches, kicks, throws, and all that stuff that is very common for the genre of fighting games. And what Judge said? Judge said that, first of all, we have the scene of fair principle here. The health bars, the use of the main protagonist, the fighters, that are portrayed in a very similar way, are the exact example of the scene of fair principle. Of course, right now we could debate whether it's possible to create a fighting game in a different way that was created by Capcom and Data East. But in 1994, the level of sophistication of the new technology of the computer and graphics was not that developed as it is right now. So in the perception of the judge, these two games should be allowed to exist from the perspective of the scene of fair principle. But judge said also yet another rule. I didn't mention this rule before because it's not that common to be portrayed, but in this particular example, judge also used the rule which is called the merger rule. So the judge basically said that if there are elements that has to be shown in particular way in terms of not just the expression, but also the way how they has to be implemented within the game, in this particular way, the movement of the characters, they has to be allowed, because when they merge both elements, the movement of the characters and the way they move cannot be protected anymore. And from the perspective of the characters used in this particular game, judge decided that Capcom cannot say that the way how the characters jump or kick are so sophisticated and so unique for its own game that it can forbid other developers for creating the same way, because it's only natural from the perspective of seeing natural living persons to kick and punch in the similar way. So this is yet another takeaway from this example. And now let's move to recent cases. 2012 is a year to remember in terms of the cases concerning video game clones. In 2012, Tetris sued Xio Interactive for creating, allegedly, the video game clone which infringed on its very successful title Tetris, known to everybody. So before 2012, the judges were more lenient to give some way of freedom, some more freedom for cloners, for developers creating video game clones, based, for instance, among others, on the cases that we have already seen in this presentation. And following that example, Xio Interactive decided to create a game that would use the benefit, the success of the Tetris game, but they knew already that there is some kind of level of legal sophistication in creation video game clones, so they consulted a lawyer. And the lawyer advised them to make some kind of differences, to rely on the sine qua non principle, to also rely on the merger legal doctrine, and to create to approach the game in a way that it uses the idea, but the expression is different. But this particular case shows that even the even copyright experts can sometimes it's not always enough to fully protect yourself from the lawsuits, and in this example, from the lawsuits that you lose. Because what the judge said, he said that, okay, the idea of creation, the game that is basically built upon and around the blocks that fall on each other and then create lines, whether in color or not, which you have to establish to score points. That's the idea that everybody can follow. But the expression of that idea, and in this example, the style, design, shape, and movement of the pieces, as well as use the exact 7 different pieces by Zio Interactive as the same ones that have been used by Tetris, was the copyright infringement. Further, the judge said that that the puzzle game was not necessarily to use the exact shapes. They could have used different shapes to also establish the same result of the game of the puzzles. And further, the judge said that the ghost pieces and the garbage lines and the preview of the next pieces did not fall within the sine qua non genre or the merger rule, that the Zio Interactive could have created that in a different way. The same year, 2012, is yet another example of the use of the look and feel principle in practice. SpryFox sued Loy Apps for copyright infringement of its own game Triple Town by creating its new game Yeti Town. SpryFox allegedly, Loy Apps allegedly created the game that was copyright infringing of the Triple Town by the look and feel principle. And on the screen you can see the 2 examples of these 2 games. On the left you will have the Triple Town, and on the right you will have the Yeti Town. SpryFox sued and said that there are substantially suspicious similarities between the 2 games, for instance in the way of portraying the main antagonist, where in the original game it was a bear, and when in the new game it was a Yeti. The object hierarchy of the game were also allegedly the same, the progressing of the game was the same, as well as the theme. We will never know what would be the outcome of the case, because this is the first example during this presentation where the 2 parties settled. So we can only debate and argue what the judge would say. If you would ask me, I see arguments to say that the Yeti Town was not infringing on the Triple Town. The game used the same idea, but different expression. The look and feel in this example, I am not able to determine at this time, because a part of the settlement agreement, the Yeti Town was struck down from the store. So we can no longer play the game. We can only rely on the graphics, on the screenshots of the game. But truth be told, if every game would be used in a way that the look and feel of the previous game would be enough to say that the game that was originally created was being ripped by the new game, the same example should be used with respect to the Asteroids versus Meteors, Street Fighter 2 versus Fighters History, and many, many other games that was created alongside the history of video games. In 2014, Glue Mobile sued Hothead for allegedly copyright infringement of its own game Deer Hunter by creation of the Kill Shot game. Both games were created around the shooter genre from the FPP perspective, with use of the realistic gun and very specific use of the aiming sights to kill with respect to the Deer Hunter, deers and other animals, and with respect to the Kill Shot to kill enemy soldiers. The bullet time animations were used in both games, but the models of the guns were different, the aiming method between the two games were different, while in one game you had this zipper when you aimed by just scrolling the zap from top to bottom, and in the other game it was on the circular matter. So these differences and similarities in the approach, in the context of Glue Mobile, were enough to say that the Hothead game, Killshot, was similarly enough to say that there is a copyright infringement. But similarly to Triple Town versus Yeti Time, both parties settled. But the difference in the settlement between the two parties is that the Killshot game was left on the market, but in exchange of the transition of some amount of the rev share revenue generated by the Killshot. So the developers of Deer Hunted say that decided that they are okay with leaving Killshot on the market, but in exchange they wanted some kind of participation in the financial benefits and success of the latter game. We can only assume that the part of the settlement agreement also included some kind of obligation of Hothead not to create any similar games in future. And surprisingly, we have not seen yet another game in that genre created by Hothead since 2014. So we talked about the law, and we talked about the cases. Now we have to answer a question. Are the clones really the villains of the video game industry? Or maybe there's something more? Let's take on the examples of the games that I used to play and I like them, and they are video clones. Let's take the Grand Theft Auto clones. The Saints Row, the Crackdown, Godfather, Scarface, Mafia, and many, many others. Everybody that like that kind of genre at least heard about these games, if not played them. They are all based around the same success of GTA 3, where you had the view from the back, from the third person perspective. You traveled around the city, you shoot at enemies, you completed missions, and you went through the storyline of all the games. They were all based on the very same idea, on the very same concept of the first GTA 3 game in this example. So imagine if Rockstar decided to go to court, battled all of the creators of these games and won. We would be ripped off of these games, of these fantastic games. Let's not went into this debate about the game themselves, whether how good they are, what are the bad feelings about these games from the perspective of the reviewer. Let's talk about the games themselves. They made an impact on the video game industry, even though they were clones. They were clones that they did not rip of the copyright protection elements of the GTA. They built on the genre. They developed the genre of the GTA to the next level. Of course, Rockstar may be portrayed and may be viewed by you as the best example, the best developer in this type of genre. But it should not forbid other developers for creating their own approach to the similar concept in their own way. Yet another example of homage in this instance is the Hexen, one of the first 3D person shooters from 1992, as I remember, and then Project Warlock from a couple of years ago. A homage to the game from a couple of decades ago, with 3D graphics, but also portrayed in the pixel art perspective. They can coexist with each other. Imagine what would happen if developers of Hexen would try to forbid creation of Project Warlock. Would that make sense from your perspective? Do you feel that this is a copyright infringement? That makes a basis for saying that these games, even though there is more than 20 years gap between them, could not coexist with each other, because Project Warlock was taking the idea, the principles of Hexen to create their own approach to video games, to modern video games. And it's a fairly successful project in that regard. Probably the newest example from the last month is The Witcher Monster Slayer, which is the newest game coming from CD Projekt Red, portraying the use of the mobile AR devices to walk around the city or walk around the plains or walk around the forests and battling monsters from the Witcher franchise. But the game used the example and the underlying storytelling, the approach to the game made by Pokemon Go a couple of years ago. And both games are based on the very same principle, the use of AR technology that we have in our modern mobile phones to put on the new layer as a video game, to use the phones, go outside homes and play video games. But the idea is the same. The expression is completely different. These two games are nothing like each other except for using the AR. But imagine if Pokemon would decide to battle CD Projekt Red, to try and forbid them for creating the games that just use the idea of using the AR technology and fighting monsters by slaying your finger through the screen of your mobile phone. Would that make sense to you? Would that work to the detriment of the development of the genre itself, the expansion of the video game industry in general? I leave the answer of this question to yourself. For the last slide of examples, let's see these modern games that everybody knew or heard of. FIFA versus PS, Pro Evolution Soccer, the constant battle between who's the better game, Call of Duty or Battlefield, King's Bounty and Heroes franchise, or the racing games like Forza, NFS, Crew. All of these games coexist with each other. They are clones of themselves. King's Bounty was the clone of the Heroes franchise, putting the building on the genre of the strategy game to the new level by adding some kind of RPG elements. Pro Evolution Soccer is the ultimate competitor of FIFA 21. The same for Battlefield and Call of Duty. Both games are first-person shooters, portraying similar conflicts, maybe in different stages of history, but the ultimate approach to the games are the same. Imagine what would happen if only the first developer that invented the FPS could be the one that create their own games. What would happen if that developer, after creation of that one game, decided that we have enough money, we don't have to develop this genre any further because we are already full with the income that we receive from that particular game? Would that work to the detriment of the video game industry or not? I leave the answer to this question to you. And now let's summary our entire presentation. Okay, so as we are reaching closely to the end of our meeting today, now it's time for the most important part for you guys. It's the takeaway section. And for the takeaway from all of the information that I gave you today and all of the examples that you have seen on the screen, I would like you to go with 4 elements that I would like you to remember while considering creation a clone by yourself, or for the instance that you approach a game that has been created by some other developer and you may feel that that game may potentially be a video game clone that infringes of your right. And for starters, every time you approach a video game clone by creating yourself, for instance, apply the filter. Try to filter out all of the elements of the game, of the both games that may not be copyrightable and may not be protected. Remember what we discussed in reference to the idea versus expression. Idea is not protected, the expression of that idea is. So try to always stay on the safe side, and if you decide to follow the idea of your competition, of your predecessor, try to the best of your ability, try to create the expression on that ideas to the most original way that it's possible, to the state of art, to your abilities, to the scene of fair as well, to the scene of fair which is like we discussed before, an obligatory element of the video game and is not protected. So after applying the filter, you decide that certain elements are protected, but the expression may be different, and some other elements of the game are seen or fair, which has to be portrayed in the game, and you are free to do so. You already have 2 bullet points that I have on you for you on the screen already fulfilled. Another 2 is apply the merge rule. So try and try and distinguish whether the idea that can be expressed in one way is then the idea and expression merge and with the way that you want to portray it in a way that neither of those is protectable anymore. Remember the example of the fighters, Street Fighter 2 versus Fighters History. The way how the characters move, it's the merge rule. They have to move in a specific way because they're supposed to move like humans. So you do not have to be worried just because your car, if you're creating a video game, a racing car, behave in a similar way to the cars in other video games, if they should behave in this way because they are cars. So remember about this rule as well. And now the last point I would like to for you to consider is always remember that the more original the original game or your game is, the more protection of copyrights and more distinguishable that game will be in comparison with another. Let's say the Star Wars. If you have the character of Darth Vader, it's very hard to create similar character similar to the Darth Vader and not being accused of copyright infringement. There's the entire persona, the way how it's portrayed, how it behaves, how it looks like, it's so unique to the Star Wars genre that would be very difficult to convince anybody that that similar character could exist in yet another universes. And if you have a feeling or urge to do so, always try to make this pros and cons list, whether you really need to put that kind of element which is so original for some other game, or maybe you can use or develop something new that would be original only to your game. And then in future, you could be the Disney who would say that my element is a new Darth Vader element that no one else should use without my consent. So this is the end of our journey. I would like to thank all of you for staying this late, staying with me till the end. And right now, if you have any questions or any comments, or I urge you and I encourage you to ask them, and I will do my best to answer them within the next session of questions and answers for the next 15 minutes. And if you have any other questions that I will not be able to answer today, feel free to contact me on my email on the screen, and I will be happy to answer.